Recording. All right, so we are now officially begun. Everything's being recorded and saved for posterity. You are at the estate planning kind of preservation, protection, information session we're going to walk through here. The whole goal today is to really talk about wills, trusts, estate planning, what it is, why you need it, how you get it, what it does for you, what are the pitfalls, kind of all of that stuff is the direction that we're going. Grace Erickson gave me a link. You'll see it in the chat. I'll post it again right here. You should be able to click directly from the chat. For whatever reason, they're collecting attendance. I don't know if you guys get extra bonus points, extra credit, right? Gilbert Public Schools. But that's the link to go ahead and acknowledge your attendance to this. Let's jump right in. So a little bit of housekeeping. So I already told you I put the link for attendance in the webinar chat. If you don't see it, just let me know and we'll get it to you. You can also see it on your screen, shared screen right there. Also, I already mentioned recording and slides and to schedule a strategy session that's free. Free whether you're with ARAG or not. Schedule that session over on lifeplanlegalaz.com/ARAG. By the way, that's case specific. So capital A, capital R, capital A, capital G. We'll get you there. A little bit about me. If you haven't been on one of these webinars with me before, I am Jake Carlson. I am a licensed attorney, have been here in Arizona since 2005. How did I end up in Arizona? Well, I went to law school in California, met my beautiful wife. She's a Californian. She wanted to stay where it was warm. I wanted to get out of California. Yes, we're those people. So we moved here to Arizona, Gilbert, a number of years ago, back in 2005, and this is where we raised our kids. I have 3 kids, one away in college now, one that is a sophomore, and final, my son, who is a 6th grader. My wife taught kindergarten for a number of years, and now she subs in the Benjamin Franklin school system. So, I mean, she's here in Gilbert, but not in Gilbert Public Schools. As far as me as a lawyer, I have a joint MBA JD. My law degree is in tax and estate planning. My MBA is in financing emerging enterprises. So businesses and taxes coming together for estate planning. We work just here in Arizona. We're only licensed in Arizona. I have 2 offices, one that is on Higley Road and Ray Road in Gilbert, and one that is practically Gilbert. I like to say it's Gilbert, but technically the Mesa is the address. It's actually right by Highland High School, and some of you work just up the street. We're on Guadalupe and Power Road in that kind of golf course there, the Fairways business section there. That's actually my main office is right there, right by Highland High School. And then my satellite office is the one that you'll see on Higley Road in Gilbert. All right. And by the way, we love Arizona. We love the D-backs. Go D-backs. And what a great game last night. What a great series. We're so excited for the World Series. Glad we didn't do this last night, or it would have been just me. And maybe not even me. What are we going to talk about today over the next 25 or so minutes? The plan today is to talk about understanding your estate planning options. What's out there? And what do they mean? We talk about wills, we talk about trust. What's the difference? Which one's better? Which one's worse? Which one's more expensive? Which one will help you today? Which one will help you later? We're going to talk about all of that. We're also going to talk about what is stopping us from having an estate plan. Or if we already have an estate plan that we did 20 years ago, I'm looking at you, why don't we update them? What's our hesitation? We're going to talk about 4 ways to transfer property, powers of attorney, and then my number 1 rule. I always get this question, and we're going to talk about, the answer is don't, but we're going to talk about that as we get going in just a bit. All right, when we talk about estate planning, we talk about 2 periods of time that are separated by 1 date in time, that date being the date that you pass away. When we think about estate planning, we often think about the after we pass away time period. What do we do with our stuff? Who takes care of our kids? That's where wills and trusts come in. And that's often what we think of when we think of an estate plan. I would argue that there's a period of time that's even more important than after we pass away, and that's if we experience an incapacity, a period of during our life before we pass away when we cannot make decisions on our own for whatever reason. Could be injury, could be illness, could be Alzheimer's, could be dementia, whatever reason we can't make decisions on our own. That's powers of attorney. Don't worry, we're going to talk about both sides of that coin. Let's start with some goals of estate planning. What are the goals of estate planning? When I ask you, why do you need an estate plan, or what would you like to accomplish with your estate plan? I will tell you that there's usually 4 different answers that I get. Number 1, it's just to make sure that what I want to happen happens. I have a specific dream for the piano that I played my entire life, and I want to make sure that the person I want to get it gets it. Make sure that our wishes are met or followed. Second, we want to reduce the cost, right? Who's paying for all this after we pass away? Well, if our estate assets are locked up inside of a house or in an IRA or in a bank account that's inaccessible, who's paying for it? Well, the kids are all of a sudden paying for funeral expenses or last illness or ambulance bills or whatever that may be. What if there was a way that we could eliminate some of those costs or reduce the costs of your estate? That's usually goal number 2. Number 3, we want to make it easy. Like, let's think about it. When we pass away, our loved ones, they're dealing with an emotional loss, right? Emotionally, they're trying to process the loss of a loved one, a parent, a sibling, a friend, whatever it may be. At that same time, they're also being asked to deal with a lot of practical issues, burials or cremations, last wishes, wills, probate, trust, handling conflicting, adult children. What if we could separate the practical and allow them to deal with the emotional, process the emotional, and then deal with the practical? Estate planning. Finally, eliminate conflict. I will tell you that 75% of estates have some form of conflict. That doesn't mean that they're suing each other. It doesn't mean that they're going out in the backyard and punching on each other. But it does mean that somebody's going home with a feeling hurt or somebody's going home unhappy. How do we avoid conflict? I will tell you that my tagline of my business is planning that prevents conflict, because I'm really passionate about eliminating conflict out of our estate planning. Okay, so now with that kind of a background, let's jump into what your options are. I really see it as 3 options when it comes to estate planning. Option number 1, you do nothing. And guess what? You're in the majority if you do that. If you do nothing, you're with 67% of the population that basically says, I'm not going to do anything. I'm going to let the kids deal with it when I pass away. Now, that's one strategy. It's not my favorite strategy, because anytime that you do that, 3 things happen. Well, 1, you get the court involved. Anytime you get the court involved, 3 things happen. Number 1, it's going to cost money. Number 2, it's going to take time. And number 3, somebody's going to screw something up. As far as money goes, you're usually looking at between $5,000 and $15,000. No plan after you pass away, $5,000 and $15,000. Time. You're usually looking at between 30 and 40 hours worth of work for your beneficiaries, for the people you love, and 6 months minimum for the court process to kind of unwind. I will tell you that it's generally around 18 months is what it ends up being, but a minimum of 6. That's the absolute minimum. And then finally, obviously, everything gets screwed up whenever you get the government involved. Don't tell them I said that, and don't let them watch this video. All right, so do nothing is an option, but not my favorite option. By the way, if we go back to the goals, ensure our wishes are honored. If we do nothing, do we meet that goal? Reduce the cost. Do we meet that goal? Make it easy. Again, do we meet the goal? Finally, eliminating conflict. So we don't meet our goals if we do nothing. Well, what's the other option? A next option is we can do it ourselves. And in fact, there's a lot of opportunities coming out now. You can go to Office Max and get a wills software package. You can go on LegalZoom and get a wills package. These are low-cost alternatives to using an attorney, but I caution you about relying too heavily on off-the-shelf no attorney involved products. And I'll tell you why. Well, actually, I don't even need to tell you why. LegalZoom tells you themselves. On the screen, you'll see a quote from the LegalZoom website that just says, I understand and agree that by using a product off the shelf that's not a law firm or an attorney and may not act as that or represent me in any regard, and its forms or templates are not a substitute for the advice or services of an attorney. So even the number one competitor, the do-it-yourself program, is saying, hey, I would still run this past a lawyer. Why? Because we go back to those same three problems: time, money, and somebody making a mistake. Unfortunately, when we do things ourselves, it's like packing our own parachute. You pack your own parachute, you don't know if you did a good job until you jump out of the plane. And at that point, it's too late to realize you made a mistake. So what we want to do is we want to make sure that we have all of our ducks in a row. By the way, this is my fastest growing segment of my business, unfortunately. Somebody who created an estate plan on their own, their kids will now bring it to me, and we'll work them through the probate process to figure everything out. Essentially, online estate planning provides fill-in-the-blank services that rely on automation to generate best guesses based on the information provided. Obviously, this process is ripe for mistakes and results in lengthy probate and higher legal fees. And then we go back to the same thing we talked about before. What are the goals of estate planning? Reduce cost, make it easy, eliminate conflict. Does doing it yourself do that? I would make the argument that the better option is to use a trusted counselor or an attorney. So why don't we? What stops us from kind of proceeding along the path and making an estate plan for our family? Well, a couple of myths that jump in. The first one is we think it's too expensive. Well, I would tell you that estate planning is actually very reasonable, certainly compared to probate and the process later on. But if you're participating in the ARAG program, I will tell you that they offer you a free trust. So there's no cost at all. That's a myth that it's too expensive. You just need to invest a little bit of your time. How much time? That's the other thing that we worry about. How much time is this going to take? Generally, an estate plan is going to take you 2 to 3 hours individually working on that. And then your estate planning attorney will probably be able to do all of the rest at that point. The second myth is that it's too complicated. I would suggest that if you feel like it's too complicated, it's because your attorney's not taking the time to step back and be an educator. With you guys working for Gilbert Public Schools, you recognize the importance of an educator. And that's what your trusted counselor, your attorney, should be. Somebody that doesn't just tell you, sign here and be happy with it, but somebody that walks you through and says, hey, here's a will, here's a trust, here's the difference, here's what I would recommend, here's why I would recommend it. Oh, you have a question? Let me know what your questions are, and we will answer them. That's what a trusted guiding counselor should do. Who to trust as far as a guiding counselor? Well, it's somebody that you know, like, and trust. So check out their websites, give them a call, meet with them on a free visit, listen to a webinar, get to know them. And then the final one, procrastination. This is the biggest challenge of all. We recognize, we know we need to do it, but we don't do it. So I'm going to challenge you that if you know you need an estate plan and you know you have ARAG, which there are 700 of you out there at Gilbert Public Schools that have ARAG. If you know you have ARAG and you know you need your estate plan, go to the link that's in the chat right now. In fact, I'm going to drop it in there again so it'll pop right up, and schedule your appointment right now and just get going. Do not procrastinate any longer. All right, now let's move to the 4 ways that you can transfer property after you pass away. 4 ways that you can transfer property after you pass away, and they go in this order, meaning that number 1 trumps all of them. Number 2 trumps 3 and 4. Number 3 trumps 4. And number 4 is horrible. That's why I drew a line through it. That's probate. One of the biggest questions, the number 1 question I get in estate planning is wills, trust, what's the difference? Well, I'll tell you what the difference is. I usually focus on three differences. Number one, wills are state-specific documents. Trusts are federal documents, meaning if you own property out of state, or if you have moved out of state or are planning to move out of state, you should definitely think of a trust because your will is going to be Arizona specific. Number two, wills are public documents. After you pass away, your will becomes a public document that your creditors, your exes, and anybody who wants to cause problems can see. Trusts are confidential. So trust will stay just with the trustee and the beneficiaries. The number three reason, and the biggest reason or difference between wills, trusts, wills always equal probate. If you have a will, you must have probate. Probate is the name of the court that manages your will. Think of it as a babysitter for your will. If you have a will, you need a babysitter. It's called probate. Now, sometimes I get the question, hey, Jake, it's just me. I own a house. I have one child. I want my house to go to my child. If I put it in my will, do I still need probate? And the answer is yes. Wills always equal probate. Trusts avoid probate. They stay out of probate. They don't need a babysitter, if you will. All right, let me jump over and answer a question or two from the chat. One question, how do we know if we signed up for ARAG? If you signed up during the enrollment period, you'll notice that there's a charge for ARAG on your paycheck. If you don't know or haven't looked and need to know, call Grace Erickson over at HR or your HR representative, and they will be able to look up your name and tell you if you're a participant in the ARAG program. All right, perfect. Okay, now back to our four ways to transfer property. The number one way that you can transfer property is joint ownership. This is very common when you have a husband and a wife or a spouses together that own a bank account, or spouses that own a house, or spouses that have two names on a car. Or it could be two brothers that bought a house together and it says joint ownership on the deed. Joint ownership is most common in spousal relationships, and that trumps everything. When your spouse dies, you get the property. So if you have a house that's two people's names on it and one of you passes away, if it's owned as joint property or community property, your spouse automatically gets it. What we're looking at is what happens when both of you pass away. All right, so then when both of you pass away, or if you only have one name on the account or one name on the house, both of you pass away. Now we look at number two, beneficiary designation. Beneficiary designations are easy to understand when we think about IRAs, 401ks, and life insurance. That's where you just list somebody to receive that asset when you pass away. I have an IRA, I name my wife, I pass away, my wife gets the IRA. I have a life insurance policy, it names my son. If I pass away, guess who gets the check? My son. Now, if you don't have a joint ownership and you don't have a beneficiary designation, now we're looking at a trust. A trust, think of a trust as like a bucket. And we're going to put assets in the bucket. Anything we put in the bucket avoids the court involvement. So if my son is under age 18 and I want him to receive my life insurance policy, I don't want to give it to him directly. Otherwise, the court has to be involved in a conservatorship. What I want to do is I want to put that life insurance policy for him in the trust. Then the trustee can manage that asset and take care of my son until he reaches an age where he can take care of himself. By the way, that age is not 18. That age is what I determine it to be. I could determine it to be 20, 25, 30, 80. I could say, hey, look, you don't get anything until you're 75 years old. I could do that. I don't necessarily recommend it. But that's the flexibility and power of a trust. It doesn't need a babysitter. It stays out of court. I'm not going to spend any time on wills and probate. The reason why is because I don't like wills and I don't like probate. Wills always equal probate. So if you don't transfer your property by joint ownership, by beneficiary designation, or use a trust, then you're left with only one choice, probate. Now, sometimes I do get the question, well, Jake, what if I don't have a will at all and I don't have any of these four? Well, guess what? The state of Arizona has a plan for you. It's called intestacy, and it does require the court to be involved. So we want to avoid that if at all possible. All right, four ways that we can transfer property. I think it's pretty clear what my personal bias is. I'm all for the trust. Now let's switch gears a little bit and talk about powers of attorney. If you recall, we started out saying there's two periods of time that we focus on. The period of time after we pass away, yes, that's our four ways of transferring property, and the period of time before we pass away. Now, we only have two options here if we become incapacitated. Incapacitated could be injury, it could be illness, could be Alzheimer's, could be dementia, could be any form of cognitive decline. But if we experience a period of time where we can't make decisions for ourselves, then we have two options. Option one is we choose who's going to make decisions for us. Option two is the court chooses who's going to make decisions for us. Clearly, I don't like that one. So I'm all for you choosing who's going to make decisions for you. We call those powers of attorney. Now, I just want to scare you for a second here. I want to talk about some statistics. The first one is every 70 seconds in the United States of America, someone is diagnosed with Alzheimer's or dementia. It is very common. I used to say, if we live long enough, we're all going to get cancer. And I think that's still true. If we live long enough, many of us are probably going to experience some form of cancer. But I've now also started saying that if we live long enough, most of us are going to experience some form of cognitive decline. Yeah. So we want to make sure that we get the plan in place before that happens, before the train is on the track heading on out of the station, every 70 seconds. The other statistic to scare you is 70% of people over the age of 60 have the markers for Alzheimer's and dementia already in their genetic coding. So it's going to be very prevalent as we age and continue to age in the future. The next two statistics basically say that the average woman in the United States of America will spend 3.7 years in assisted living. The average man will spend 2.2 years in assisted living. We just can't live that long there, I guess, guys. Sorry. But with that, that's why it's so important that we give the power to make decisions to somebody if we ever cross that line and can't make them for ourselves. Statistically, it's going to be many of us, most of us, if not all of us, that are going to need someone to step in. Better to choose for yourself than to allow the court to choose. And those truly are your only two options. Powers of attorney, where you choose, guardianship, conservatorship, where the court chooses. All right, let me just check over here and see if there's any exciting things happening in the chat or in the Q&A. All right, moving right along. So I often get the question, Jake, hey, can I just add my daughter to my bank account? Instead of doing this power of attorney stuff, instead of worrying about all this, isn't it easier if I just grab my daughter, we run over to the bank, I add her to my account? What do you think about that, Jake? And I will tell you that my opinion is don't, with 2, 3, 4, 5 exclamation points. Don't do that for 4 reasons. And the 4 reasons are, number one, when you add your child, or if your parents want to add you to their bank account, when somebody else is added to your bank account, it acts as a taxable gift to that person. And the person, the parent who owns the account, must file a Form 709 with the IRS, letting them know that they have now made somebody else a joint owner of that account. So, tax situation. Number 2, additional risk. The second reason that I don't like to add kids to bank accounts is if that child is in a car accident, or if that child has a disability, or if that child is sued or goes through a bankruptcy or gets divorced, your account can be pulled into that lawsuit. So you increase the risk to your assets by adding children. The third reason is if you have more than one child, it could end up in unintended distributions. So if I add my daughter, I have 3 kids. If I add my daughter to my account and I pass away, my daughter gets that account free and clear. That's because if we go back here to number 1, she is now a joint owner to the account. As a joint owner, it's now hers. I passed away, one of 2 joint owners passes away, the other one gets it. There is no legal obligation for her to share it with her 2 siblings. Now, she might, if she has a good heart on her, a good head on her shoulders and heart in her chest. But why do I want to risk that? Number 4, the fourth reason I say don't is because you don't have to. With the power of attorney, you have the ability to eliminate those 3, the taxable gift, the additional risk, and the unintended distribution, while at the same time allowing a child, one that you love and trust, in this case, it could be my daughter, to make decisions on my behalf to pay my bills and deal with my bank accounts and do all the things that need to be done without the risk of those 3. So I say, look, those 3 are cons, but the biggest pro of a power of attorney is you don't have to deal with those 3 cons. It eliminates them completely. So that's why I say don't when it comes to adding my kids or being added as a kid to a bank account. All right. Before I get to this next slide, let me just kind of wrap up on the power of attorneys by saying this. If you've already added a child to your bank account, don't lose sleep tonight worrying that the world's coming to an end. Everything is fixable. I'm a big proponent of this idea that everything is figure-outable. We can figure it out. So give us a call. Let us know. We'll sit down with you. We'll walk you through what your options are as far as trusts, wills, making sure your home doesn't end up in probate, making sure that your powers of attorney are sufficient, and also figuring out what we need to do with that bank account. All right. Let me take a minute and pause and just say, are there any questions? It's been a little bit quiet in the chat today, so I want to make sure that anybody who has any questions will be able to ask those questions. So go ahead and either drop them in the Q&A or drop them in the chat, and I'll be able to answer them. Or if there's no questions, let's kind of move on. Whoops. Next one. What's next? All right. So what's next? If you're participating in the ARAG program with Gilbert Public Schools, you get your trust, your will, your powers of attorney, the home deed. You get that whole package taken care of by ARAG. So, go ahead, go to that link, lifeplanlegalaz.com/ARAG. Remember, that's case specific. And right there, you can schedule everything. You can do it all and no cost. Now, if you're not with ARAG, that's okay. We can still help you. And we'd love to help you. We would. We give 25% off our normal packages. Go ahead and give that phone number a call and we'll work you up. Now, I do see a few notes popping up in the webinar chat. So let me jump over there for a second and kind of look at those. What are the different types of trust? Oh, great question. Typically, we talk about 4 different kind of terminologies when it comes to a trust. You may have heard about a testamentary trust. You may have heard about a revocable living trust. You may have heard about an irrevocable trust. And you may have heard about a revocable testamentary trust. Okay, well, what are these terms? Let's start first with revocable versus irrevocable. A revocable trust is one that you can change throughout your whole life. Irrevocable trust, irrevocable means you cannot change it. Once you set it up, that's unchangeable. Now, you can change the assets in it, but once you set up the trust, it's unchangeable. Now, a lot of times I get the questions, Jake, what do you recommend, a revocable or an irrevocable? Well, in a group this size, I can't give a specific answer, but let me tell you this. 99% of the time, I recommend a revocable trust. The reason why is because you can change it, you have full control over it, and there's some negative consequences with an irrevocable trust that I don't like. The negative side of an irrevocable trust is obviously, number one, you can't change it. Number two, as a trust, irrevocable, it's taxed as a separate entity from you. And generally, it's going to pay about 10 to 12% more in taxes than you would. So irrevocable ends up with a little bit more in taxes. Number three, I'm very strong advocate for senior independence, not relying on your kids. In order to use an irrevocable trust, you have to transfer those assets to the kids or transfer. This is just a general blanket statement, but the more control you give up on an irrevocable trust, the more of the irrevocable trust benefits you get. What is the irrevocable? After I just told you the cons, you might say, well, why would anybody choose an irrevocable? You would choose an irrevocable trust if you're worried about lawsuits, if you're in a high litigation field, like a doctor or a dentist, where you're afraid to get sued. For most of us, including myself, we're better off using a revocable living trust and then just increasing our insurance coverage to make sure that if we're sued, we're covered. So that's a great question. Oh, second part, living versus testamentary. Living just means you set it up during your life. Testamentary means it's set up through somebody else's estate plan. I'll give you an example. You come in to visit with me and you say, hey, Jake, I want to set up a trust. We set you up with a revocable living trust because we set it up while you're alive. But in your trust, you say, hey, look, if I pass away, I want it to go to my kids, but I want it to be in a trust protected for them. Their trust is a testamentary trust created by your living trust. All right, great question. Now, if you have additional questions about irrevocable versus revocable, give us a call. Let's sit down. We'll talk about your situation. I can give you a little bit more detail about that. I'm not very pro irrevocable. I'm very pro revocable. All right. If we are not members of the ARAG program, how would we find out pricing per document or hourly fee? You could call the law firm and find out if they're willing to share it. I will tell you that my law firm, we don't do anything hourly. Everything is done at a fixed cost. Generally, a trust is going to be in the neighborhood of $1,600 to $3,600, depending on some of the factors: home ownership, disabilities, how many kids, what kind of do you own a business, those kind of things. And then, of course, take the 25% off that. We can walk you through the pricing. Our pricing is all straightforward. We can send you a sheet that shows you exactly what that is. What triggers power of attorney? Oh, that's a great question. Powers of attorney can be triggered by, well, let me back up and first say this. A power of attorney is only effective if you're unable to make decisions for yourself. If you can make decisions for yourself, you can always override any decision. So for example, you make your daughter your agent and your daughter says, hey, I think we need to do X. And you say, I don't want to do X. Then you just override it. The effectiveness of a power of attorney is always overridden by you until you reach the point where you cannot override it, meaning you're incapacitated. So incapacity may be more what you're referring to when it comes to what triggers a power of attorney. Incapacity does. Now, there's two ways that we can define incapacity. Number one, we can define incapacity by we just can't make the decision. Our family says, hey, look, dad's struggling. We need to go to the bank or the financial institution. We need to step in for him. It could be triggered by the family saying, hey, look, I don't think dad should be making decisions. Or it can be triggered by a doctor saying, hey, Jim can't make decisions. Sally shouldn't be making this decision on her own. Which one do we choose? It's really up to you. We usually talk about that. That's one of the other reasons that we sit down with all of our clients to talk through your specific situation to find out what type of safeguards need to be in all of your documents. What if you move to a different state after having your trust done in Arizona? I love you put the golf ball right on the tee for me. Hey, I'll tell you what, I love these questions. Thank you. If you move out of the state of Arizona, your trust is governed by federal law. No problem. It should be valid anywhere that you go, should operate the same way. Your wills and your powers of attorney are state-specific documents, so they will be interpreted under the state law of the state you move to. Generally, your estate, your powers of attorney, and your wills will be valid in whatever state you go to. All 50 states have a statute that says if you bring an Arizona document to Colorado, Colorado must honor it under Colorado law. So there can be a little discrepancy between what Arizona allows and what you thought you were going to get, and what Colorado allows and what you thought you were going to get. I usually say treat it like your driver's license. If you go on vacation to Colorado, use your Arizona driver's license. If you move to Colorado, it might be time to go see the MVD and get an updated Colorado license. You might want to sit down with a local attorney in your new jurisdiction. Or if the question is, hey, I just moved here from California, Jake, should I sit down with you? Yeah, come sit down with us. We'll walk you through. We'll say, this is what we see and the risk factors that we see. By virtue of moving does not necessitate a change. All right, what if an aging parent refuses to share his wishes with you, but is making poor financial decisions? Unfortunately, so two answers to that question. Number one is, I always say that the fastest way to avoid problems with inheritance, in fact, 90% of all problems with inheritance can be avoided if parents would just speak with their children before they pass away. They would just be open and upfront and honest with them before they pass away. What happens if they're not being that? Well, we can't force them to do it. Or can we? Yes, unfortunately, but it's a time-consuming and pricey proposition. It's called guardianship. It's called conservatorship. Powers of attorney won't work. If you're saying, hey, look, my dad gave me, I have power of attorney for my dad. I'm the agent, but I'm going to the bank and I'm trying to do it. My dad's saying, no, you can't do that. He's overriding me. Then you're kicked into the court. Once the court makes a decision, it takes all of the power out of mom or dad's hands to override your decision. We call that guardianship for healthcare decisions. We call it conservatorship for financial decisions. Unfortunately, you're probably going to head down that path if parent is being a little bit obstinate about it or making poor decisions and we can't jump in. All right, let's look at this one. What about purchasing a new home? My daughter and I recently moved to Arizona and hope to buy a new home next summer. Congratulations, welcome to Great State 48. I'm sure that you'll be loving it as much as I did when I transferred here. I love it. Is it advisable to put it in both our names? Okay. Can I give you a lawyer answer? You hate these lawyer answers. You just want me to give you a yes or no, but I'm going to give you a lawyer answer. It depends. I'll tell you the upside and the downside. If you and your daughter are equally putting finances into the house, and if at the end of your life, because likely, at least statistically, you're going to pass away before your daughter passes away, likely it's, if that's the case, hey, I want it to go to my daughter, we're both contributing to it. Yeah, joint tenancy with right of survivorship, no problem. If you're saying, hey, look, I have multiple kids, I just thought it'd be easier if I put my daughter's name on it, you're fraught with probably some potential problems. I would recommend that you sit down with an attorney before you sign on the dotted line and just say, hey, here's my specific situation. What would you recommend in this situation? Okay. Oh, I see. Yeah, that's a follow-up to that question. Will this have effect within the will or trust down the road for my daughter? Ah, so joint ownership, if I go back, let me go back a few pages here. Joint ownership is going to trump whatever is in the will or the trust. So let's say that you say in your trust, I want my house to go to John, but you own jointly your house with Amy. Okay, Amy's getting that house. Even though your trust says to give it to John, Amy's getting it because joint ownership trumps will or trust. Better just put it in that bucket, the trust, and then you can give it to Amy, you can give it to John, you can have them split it. You can say, hey, look, I don't care what you guys do with it, sell it, split the money, or split it 90-10, I don't care, but you can control that with your trust. All right, let's go back over here. I had some difficulties getting logged into the meeting, so missed some of your information from the beginning. Will the slides be available? Hey, talk about putting the golf ball back on the tee for me. Yes, not only is the slides already up on the website, I just put it in the chat, but so will this recording. So you can go back and listen to my lovely presentation from the beginning on that same website. And if you have questions, you can always contact us through that as well. So this is being thank you. Is that Grace? Grace, you're the best. Yes, that's the answer. If my parent has put me on their bank account already, but also has a trust in place, can they just remove me from the account? Does something else need to be done? What needs to be done is you need to go with your parent to remove your name. Now, this is something that I would actually run past myself or another attorney before you actually do it, because I don't know your situation. If it's just you and you've already named and they've already put you on the account, and then in the bank, in the trust, it says give it to you anyway, you know, you've already kind of crossed that line. You might as well just leave it. But I don't want to say that as a broad statement, not knowing your specific situation. But yes, if you want to just take your name off so that you eliminate, some of the liability risk and the gifting and all of that, yes, you would go down with your parent to the bank. Both of you would sign off, and then you would transfer it to the trust. Should a husband and a wife have vehicles in both names? Wow, another golf ball right up on the tee. Arizona does not recommend that you put your vehicles in the trust. They actually recommend that you use what's called a beneficiary designation form that you can get on the ADOT website. Basically, what you do is you put both names, spouses, on the title to begin with. When one of you passes, the other of you gets it without having to do anything. And then you fill out a beneficiary designation form, put it in your trust document for when the second of you passes. If you only have one name on the car, so a husband and wife bought a car together, but they only put husband's name on it because he qualified for the loan, or the wife because husband wasn't able to sign. In fact, that's what happened to me. My wife and I were at the car dealership. We were buying a car. I said I had to be done in 30 minutes. They laughed at me. I walked out the door. My wife stayed, signed for it. The car's in her name. No problem. We still just filled out a beneficiary designation form. It goes to me after she passes away. We did nothing with the title. We just left it in their name. Very easy. Either way, I think Tracy should be the answer to that one. Great smiley faces all around. Any other questions? I appreciate you guys hanging out with me for a little bit longer today. I usually try to stay about 30 minutes, but you're welcome to kind of pop off when you want, but it does look like a question jumped up. What if we own a business? What happens with that if one person passes away? Well, if two of you own a business, where you look on the Arizona Corporation Commission and both of you are owners of the business, then it really goes by your either corporate bylaws or your articles of incorporation. Whatever the operating agreement says, that's what the Arizona Corporation Commission will handle or follow in that regard. Now, if both of you pass away, or if it's only in one name and you pass away, then we have probate. So what I recommend that you do is you take your business, you put it in your trust, you give your trustee the ability to assign that business to whoever you want it to go to. What other items other than cars are usually not included in the trust? Well, so cars, let me go to this page. So cars are the number one. The other thing is the primary beneficiary designation assets, IRAs, 401ks, annuities, where you just list, hey, I want this to go to my spouse when I pass away, not into the trust. I want this to go to my kids when I pass away, not in the trust. IRAs, 401ks, life insurance, vehicles. Those are typically what we recommend that you use the beneficiary designations for. Everything else, your stuff, your firearms, your couch, your television, your gold bricks buried in the backyard, into the trust. Your house, into the trust. Your businesses, into the trust. Everything else in the trust. Oh, bank accounts, checking, savings, investment accounts like a Robinhood or an E-Trade that you're managing either on your own or through an investment advisor that does not have a beneficiary designation, into the trust. All right. Well, you guys are very, very welcome. Thank you for hanging out with me. Again, everything that we talked about in this. Oh, whoops. I totally jumped off. I went too fast through the slides. There is one last slide that I want to show you, and that is coming up. Sorry about that. I went too fast, and when I got to the end, it just cut it off. We already talked about the link. I'm going to throw the link in one more time for you here. If you didn't get a chance to confirm your attendance for today, go ahead and just use this link here, and you can confirm your attendance. The other thing that I wanted to mention is that the Gilbert Public Schools Financial Benefits Information Center. There is a link at the bottom of the screen there, sites.google.com/gilbertschools.net financial benefits home. I'm going to go ahead and just copy that link and drop it into the website here. This is where all of the resources that Gilbert Public Schools offers as part of some of the HR work, the stuff that Grace is doing, is all found here. The old presentations, this is my third time presenting with Gilbert Public Schools. My other two are also on there, plus some other benefits there. Okay, any relation to Carla Carlson? Carrie Carlson, K-A-R-I, is my wife. Carla, I don't recognize that name. Where do we confirm our attendance? If you just look up a little bit higher, there's a forms link. I'm going to throw it in right now. Let's see. I got it coming here. This is the direct link to confirm your attendance right there. Just click on that in the chat. Okay, so this is going to be our last call for questions. Any additional questions? Otherwise, I am going to let you guys get on with your night tonight, and I look forward to seeing you guys again. Again, use that link, lifeplanlegalaz.com/ARAG. It is case specific. If you use that link, you'll get right to my information, the slides, the review, and all of that. Would it be less expensive to wait until benefits enrollment to sign up for a trust, or should I arrange it now? Marcia, that's a great question. I will tell you this. The ARAG package is fantastic. I really like what they offer, what we give to you as a member of ARAG. That being said, I believe the enrollment window is April. So we're looking at a little bit of time between now and then. So, we roll the dice. We save a little bit of money today, but there's a chance that we jump out of the airplane too soon. On the flip side, if you're young, you're healthy, you feel like, hey, everything's gonna be good, April's just fine. Yeah, wait till open enrollment. We did have a few people last year that said, hey, April will come by. We got a call from them in April. They were signed up and ready to go, and we got their trust done in a matter of 2 to 3 weeks. All right. Okay, well, you guys are awesome, especially being, working in the school district. Thank you, thank you, thank you. I'm going to go ahead and shut this off now, but feel free to reach out anytime. You guys are amazing. Appreciate your time and have a great, great evening.